We're ready now to resume, so I'll invite Ms. Montfield, Queen's Counsel, acting on behalf of the Consul General for Wales, to resume her submissions.
Thank you, my lord. I was at the stage where I was talking about distinguishing the Continuity Bill case, where Section 17 of the Continuity Bill was held to impugn parliamentary sovereignty, which is Section 28(7) of the Scotland Act. But in that case, the very intention of the impugned provision was to remove the right of the UK Parliament to legislate for Scotland in relation to retained UK law, retained EU law, without Scottish parliamentary approval, by rendering any future UK legislation passed without that approval as being of no effect. You see that in paragraph 52 of that judgment. But in the present case, by contrast, the Scottish Parliament has simply exercised its own competence for a statutory purpose which is within that competence, i.e. to protect children's rights to the maximum extent possible in Scots law. And to the extent that this is a modification of the law, including of a prior UK parliamentary statute, that is something which is open to the Scottish Parliament to do expressly or implicitly because of the doctrine of implied repeal. Any other UK parliamentary legislation that's already on the statute book stays on the statute book without any requirement for Scottish parliamentary authority to keep it there. And unlike Section 17 of the Continuity Bill, there is no limitation within the terms of Section 19 of the UNCRC Bill on the power of the UK Parliament to, again, expressly or impliedly, legislate in a way which either repeals the Section 19 of the UNCRC Bill or evinces the very clear intention not to be bound by a interpretation that is compatible with the UNCRC, because the whole thrust of that UK parliamentary legislation is such that it would not go with the grain of the legislation, to use that Guide and Gillam phrase, for that legislation to be interpreted compatibly. So it's not a case where the only way that UK Parliament could exercise its sovereignty is to repeal the provision which purports to limit it. It's just not that sort of provision at all. Can I then come on to the what we say is a misappreciation in the law officer's submissions of the concept of parliamentary or legislative intention? And this is has constitutional importance because the law officer's submissions make repeated reference, as indeed, in fairness, there's a lot of case law, to the concept of parliamentary intention, and suggests a danger that an interpretative obligation such as Section 19 of the UNCRC Bill might flout parliamentary sovereignty by flying in the face of the intention of a parliament which passed some other earlier piece of legislation. But in my submission, this is to elide in a confusing way the concept of the judicial exercise of identifying the legislative intention, the intention of the statute, as if its intention evinced in the statute, and Parliament's intention. Statutory intention is not the same, of course, as the intention of the executive which introduces the legislation into Parliament, nor is it the same as the intentions of the individual members of the legislature who voted for the statute. Because respect for the rule of law and legal certainty, the concept we've been talking about, means self-evidently that the law is what the statute says, and it is for the court to determine what that means. And it does that by seeking to identify an objective intention, the objective meaning of the words used in the statutory context in which they fall to be interpreted, using the canons of statutory construction which are known to lawyers, the various presumptions which apply, and which are part of the common law. So the rule of reason, fairness, equal application, unless the contrary otherwise applies, and so on. And the important recent case law that establishes that this is the role of the court, or reiterates that this is the role of the court, is to be the dicta, relevant dicta, to be found in Privacy International. In view of time, may I just give you the references? I'll take you to them if you want, but it's Lord Carnworth at paragraphs 130 and 132 on page 2429. And he talks about the way in which, in that case, interpreting an ouster clause, there's a balance to be struck by the judiciary between identifying the inferred intention of the legislature and the fundamental principles of the rule of law, which you have to achieve an interpretation of legislation that interprets the statute, assuming that those fundamental principles will be respected and maintained in the respective roles of those bodies. And then Lord Lloyd Jones, in the same case, paragraph 160, 2437, said that the interpreter of the law must always be an impartial, independent and authoritative judicial body. And that matters because of the discussion that you were having with Mr. Muir before the short adjournment about the relevance of the views of the person responsible for the bill and the presiding officer. It's always the court that has the ultimate authority to interpret legislation. And finally, I cite, penultimately, I cite the late Sir John Laws in The Constitutional Balance. That's in the bundle at page 3063. And the whole of that the chapter is worth reading in this context, but the citation in my written case is at 3070. In the Continuity Bill case at paragraph 12 on page 857, it was said that the purpose of the framework, the shape of the Scotland Act was to give a constant and predictable meaning of Scots law within competence. And it's my submission that a constant and predictable meaning is far more likely to emerge from the establishment by the Scottish Parliament of an overriding principle of construction, like section 19, than by a case-by-case analysis of the way that the general common law presumption applies. And there's nothing unusual or constitutionally problematic about that in my submission. In relation then, in that context, to the question of the Scottish Parliament's authority being in some way delegated to the courts, I adopt the submissions made by Mr. Muir, and to the extent that an individual statute does need to be interpreted on a devolution issue arises in the interpretation of an individual statute in the light of section 19 of the UNCRC, it's difficult to see why that is in some way a delegation. That's the ordinary function of a court, not the person in charge of the bill, the presiding officer. May I then turn briefly, and Lord Reid, I'm in your hands on this because I think I've probably had my hour, but I did want to make some short submissions on section 101, the approach to section 101.
Yes, well, it may be that one of us has got the wrong arithmetic. It may be me. I think you've got another 10 minutes or so you're welcome to that.
I'll take my 10 minutes. Thank you very much. And just to be clear, I'm not referring to anything to do with the way that the section 101 is used as a drafting device in the UNCRC bill, which is a matter for Mr. Muir. I want to talk about the approach to section 101, which affects our approach to section 154 of the Government of Wales Act. And my three submissions are, firstly, that no textual ambiguity is required to trigger the use of section 101. Secondly, however, that section 101 properly construed goes further than simply giving effect to the principle of efficacy. And thirdly, and in a sense it may echo some of what I said earlier, what is a possible reading of legislation is one which is in accordance with Parliament's intention, judged objectively, and in this context is subject to the same limits as the limits that apply to section 3 of the Human Rights Act. That's the Gillam limit of whether the reading goes with the grain of the legislation. But it is a question still of construing the legislation, not of legislating. So on the issue of ambiguity, may I take you to two references that Sir James and Mr. Muir took you to? Firstly, the explanatory notes So James took you to those notes, which are on page 442 of the electronic bundle, the explanatory notes to section 101, in support of his submission that section 101(2) is not intended to be capable of being applied to language which is not ambiguous. That was Sir James's submission. But the example which is given in the explanatory notes actually contradicts that submission. That example says, for example, an act of the Scottish Parliament which purports to confer a power on Scottish ministers to hold a referendum on any matter could be read as enabling ministers to hold a referendum on, say, independence or the monarchy, and those are reserved matters. And the Act of the Scottish Parliament might therefore be read as relating to those reserved matters and therefore outside the scope of competence. Rather than invalidating the ASP, or invalidating it to the extent that it could be so read, this section would require the ASP to be read, if possible to do so, as conferring a power to hold a referendum only on matters within the competence of Parliament. And if it can't be read within that competence, for example, it's an ASP providing only for a referendum on independence, then the section will not allow it to be read as being within competence. So this example envisages not just apparently unlimited general words, a power to hold a referendum, but explicitly unlimited general words, a power to hold a referendum on any matter. Now, those aren't ambiguous words in a textual sense, but the explanatory notes nevertheless suggest that section 101 could, if it was possible to do so, be used to read that provision down as applying only to matters within competence. And it's only, according to those notes, only if a provision clearly can't be read within competence that section 101 couldn't be used. Now, I do accept that there's judicial authority, and it's Lord Reed's your authority, that the explanatory notes have certain limited relevance. I take you to that because Sir James relied on it. But the notes on clauses, which are contemporaneous with the introduction of the bill, are more authoritative. And Mr. Muir took you to those, and they're at page 477 of the electronic bundle. And those said, in relation to what became section 101 of the Scotland Act, that this provision is intended to ensure that the courts will, in cases of doubt, tend towards a stricter interpretation of the effects of ASPs, thus reducing the scope for practical problems resulting in consequence of the declaration of apparently valid ASP as ultra vires. But in the light of the shift of the case law, which Lord Reed noted in the UBS case, to a purposive construction, cases of doubt can't mean only cases of textual ambiguity, can also include contextual ambiguity. And the case law on section 101 itself demonstrates that such
The application of a purposive construction came late to revenue matters, but purposive constructions of statutes more generally would have predated the 1998 Act, would they not?
Yes, my lord, absolutely. And that's why when the explanatory notes in 1998, or may have been late 1997, but the explanatory notes around the time, sorry, not the notes of clauses, I mean, said in cases of doubt, that must have meant contextual doubt, not just textual doubt, because of the way doubt was construed at that time.
But it is interesting that the note and clause does speak about something that is an apparently valid ASP. So it doesn't seem to be looking to the wide-ranging exercise that the Lord Advocate would impose on the courts.
Well, my lord, I'd say that the exercise here is like the general provision for holding a referendum, that you can read it down to say, unless it's otherwise outside your competence, you take that from the context. And what I was going to go on to say is that the case law on section 101 demonstrates that such contextual ambiguity may arise, even in circumstances where the words on their face appear unambiguously to be outside competence. Although, of course, subject to that limit of a possible reading, and the more less ambiguous the wording is, the harder it will be to save it. So the Welsh bylaws case, page 815, Lord Neuberger said there were no express words in section 9 of the bylaws bill which would permit the bill to be used in particular circumstances, but held that it would be permissible to use section 101 to limit the apparently unlimited and general effect of the section. It's generally, I'm sorry, it is the Welsh bylaws case. He was talking about section 101 though by analogy. That's why I was hesitating. Now, I do acknowledge that Lord Neuberger also said at paragraph 64 of that case, also on 815, that section 101 couldn't be invoked if it was inconsistent with the plain words of the section. But when we read paragraphs 63 and 64 of that judgment in the round, he must have been drawing a similar distinction to that in the explanatory notes in relation to referenda, that adopting a narrow reading of general words is permissible, but a provision that's clearly outside competence can't be brought into competence by adopting a reading which doesn't go with the grain of the legislation. And in that same case, Lord Hope, at paragraph 84 on page 818, accepted or noted that on the face of it, the relevant power was open-ended, but it falls to be read as narrowly as is required for it to be in competence. And in the Legal Continuity Bill case, the Supreme Court held, this is paragraph 77 at 869 of the electronic bundle, that if it were necessary, the court would have read the apparently general power in the relevant section narrowly to apply only in situations of incompetence. In the case of Henderson, this is 1952 of the electronic bundle, paragraph 10, the High Court of Justiciary applied section 101 of the Scotland Act, notwithstanding the broad terms of section 1 of the Criminal Justice Scotland Act, which was read down. So that's what I say on ambiguity. Then issue 2, section 101 going further than the principle of efficacy. This is supported by the case of Anderson and the Scottish Ministers, 2001. And the key passage for our purposes on page 1390, paragraphs 34 to 36 in the speech of Lord Hope. And he held that but for the interpretative obligation in section 101 2, paragraph 35, the relevant provision, which in that case was a provision of mental health legislation, would have to fall. And the reason it would have had to fall was because it was incompatible with the convention rights of one individual. D, you see that in paragraphs 34 and 35. But Lord Hope considered that it would not be in the public interest for section 1 of the 1999 Act to be struck down simply because it was incompatible with one individual's rights, convention rights, D's convention rights. So he said that had it proved necessary, he would have used section 1021 in order to suspend the effect of the decision to strike down the provision for 3 months, so that he would enable the Scottish Parliament to correct the defect. But, and now we're looking at paragraphs 36 and 37, that wasn't necessary because by applying the interpretative obligation in sections 101(2), he held that the word public could be given a narrow meaning, so that just that section of the public who are in prisons, and that could save it without the need for further amendment. So it follows that section 101(2) must go further than the common law principle of efficacy, because using only the common law, including that principle, Lord Hope could not have saved the provision from the mental health legislation. He had to use section 101(2) in order to do that. The third issue, which I can take quite shortly, I think, is that what is a possible reading, is one which is in accordance with parliamentary intention objectively judged, subject to the same limits as section 3 of the Human Rights Act, we say. Now, I've made this point, but what is a possible reading depends partly on the language used, but for a phrase in the case law, you don't read the text without raising your eyes to look beyond it. The context is also relevant. and key to the context is parliamentary intention, but not the subjective intention of the Scottish Parliament which passed the bill, the particular bill. And that's contrary to what the law officers suggest in paragraph 105 of their written case at page 156 of the bundle. The intention of Parliament is to be judged objectively. And for this, I rely on what Lord Hoffman said in Wilkinson, and it's quoted in Craze, really is quoted in Craze, this bit. It's page 2984 to 5 of the bundle. And he's talking about the Guyden case. The statute, the housing statute that was being construed about statutory succession in Guyden. And he said that it may have come as a surprise to the members of Parliament, which in 1988 enacted the statute construed in Guyden, that the relationship to which they were referring could include homosexual relationships. And in that sense, the construction may have been contrary to the intention of Parliament. I'd say contrary to the intention of that Parliament. But that is not normally what one means by the intention of Parliament. One means the interpretation which the reasonable reader would give to the statute, read against its background, including now an assumption that it was not intended to be incompatible with convention rights. So once you have a provision, a general provision, then in ascertaining the intention of Parliament, then as part of the context and background to the statute, the court should take into account the presumption that the Scottish Parliament intended at least to limit themselves to what they had the power to do. Now, that's not the same as a presumption that all Scottish Parliament legislation is within competence, but it is a presumption that the Scottish Parliament intends to legislate within competence. And the very fact that Section 101 is included in the Scotland Act is itself a powerful piece of evidence to support that presumption. And it is also indicated by the requirements under Section 31 of the Scotland Act and the equivalent under Section 110 of the Government of Wales Act, that the person in charge of a bill must make a statement that the provisions would be within legislative competence. So it's like akin to Section 19 of the Human Rights Act. In the case of DS and Her Majesty's Advocate in 2007, this is 722 of the electronic bundle, paragraph 24, the court said that the court must prefer compatibility to incompatibility. And I accept, of course, that that was a statement made in relation to the interpretative obligation in Section 3 of the Human Rights Act. But we submit that it's a general application, and so it applies equally to Section 101 when that's being considered. Now, I also accept, of course, that clearly there are some limits as to how far the court can go in adopting a reading that brings something into competence, but I respectfully submit that those limits are the same as those in Section 3 of the Human Rights Act, including the same language and passed 10 days earlier than the Scotland Act, and as part of the same exercise of a new constitutional settlement. Now, I don't, for the avoidance of doubt, suggest that Section 101 of the Scotland Acts and Section 3 of the Human Rights Act are the same in all respects, and we say that in paragraph 32 of our written case at page 230. And the reason I say they are different in some respects is that there are various interpretative tools available under Section 3 of the Human Rights Act, including a strained construction and reading words in and reading down, which are not available under Section 101. Section 101 allows only one tool, if possible, to put something within competence, which is a narrow reading. But while I say the tools that are available under Section 3 of the Human Rights Act and Section 101 of the Scotland Act are different, the purpose is the same. And the purpose is to adopt a possible reading of the legislation to enable it to be given effect, if possible. So it ought not to be surprising that what is a possible reading should be treated in the same way in both acts, given that they were given royal assent some 10 days apart. Now, in the course of argument yesterday, my Lord Sales suggested that the fact that there's a developed body of case law in relation to convention rights, which already existed when the Human Rights Act was passed, might provide an indication that Parliament intended Section 3 of the Human Rights Act to be approached differently to Section 101 of the Scotland Act. And I respectively submit that this is an imaginative hypothesis, but it isn't borne out by the contemporaneous materials. Firstly, I should point out that there's a body of authoritative guidance concerning the meaning of the UNCRC in the form of general comment, and that was accepted by the whole Supreme Court in Mathiasson, and again then in the second benefit cap case, DA, to be authoritative guidance, although of course, like European Court of Human Rights guidance, it's not binding. I can just give the reference and then I'll so that's paragraph 67 to 69, 2337. Yes, my lord.
I was just wondering why you say that a narrow reading can't use the tool of reading words into a piece of legislation. And I understood you to say the same tools weren't available, that it was restrained, that the
yes, my lord, you're right. Now you could read words in to make it narrower. What you couldn't do is broaden it out if you needed to do that, to make it so it's not like Human Rights Act compatibility in that sense. You are right. I'm sorry, I went too broad in my narrowing.
Thank you very much indeed.
Lord Sales.
Yes, sorry, just on the point of distinction possibly between the Human Rights Act and the Scotland Act, I'm not sure that saying that there's a body of guidance on the UNCRC addresses that point. The point was that, as I think Mr. Muir acknowledges, the boundaries of competence in Schedules 4 and 5 are long and complex and uncertain, and there isn't any guidance as to how they work. Whereas in relation to the, if you like, simpler provisions of the Human Rights Act, you get the Human Rights Act plus the body of case law in relation to that. So it's not a comparison between Human Rights Act and the UNCRC, it's between Human Rights Act and Scotland Act.
Yeah, my lord, I'm only smiling because the concept of these provisions being simple, since I've made quite a life out of them being quite difficult. But yes, the point about the UNCRC was an aside, but the suggestion that the European Convention on Human Rights provisions were in 1998 subject of a simple or established body of case law that set out what they meant is not, in my submission, something that the preparatory material suggests was in the mind of the Parliament that passed this legislation, because if one goes to the white paper, Bringing Rights Home, there's nothing in that leads to suggests that Parliament felt able to draft Section 3 of the Human Rights Act in the way that it was drafted because of the existence of a body of previous European Court decisions. And indeed, it was known at that time that the European Convention on Human Rights was applied as a living instrument. So the case law wasn't settled at that time, it remains unsettled today. And indeed, that white paper, Bringing Rights Home, expressly says that Parliament is looking forward. And if you look at paragraph 2.8 on page 3089, you can see that Parliament is not looking back towards previous European Court decisions, but looking forward to the development of a new body of case law. So my submission is that at that stage, Section 3 constituted a new and purposive approach to a constitutional settlement, and that was equally true of Section 101 of the Scotland Act. And the clearest indication in the case law that there should be the same approach to the limits of what is a possible meaning, a possible narrow meaning under Section 3 or Section of the Human Rights Act or Section 1 of the Scotland Act is to be found in Anderson and the Scottish Ministers, page 1390, paragraph 36 of the Privy Council decision. And in that case, Lord Hope explicitly bore in mind what he'd said in the Lambert case at section 78 to 81, when he'd been considering how Section 101 of the Scotland Act could be used. And Lord Hope said these observations were relevant. Lambert, rather, was a case about Section 3 of the Human Rights Act, but Lord Hope considered that those observations were relevant because Section 101 of the Scotland Act was, he said, the corresponding obligation. And then finally, the limits imposed on the use of Section 3 to ensure that it doesn't cross the boundary from interpretation into amendment are well known, and I don't need to address those at length orally, but the best encapsulation is perhaps that of Lord Roger in Guyton at paragraph 121 and 704, and endorsed by Lord Nichols at section 33, paragraph 33, I'm sorry, 687, that a sympathetic reading must nonetheless go with the grain of the legislation. And we submit that although that was about words being read in under section 3, they're equally applicable in a situation where a provision is read down under section 3, the Human Rights Act, or section 101, or indeed, as my Lord Stevens suggested, if words are read in too narrow, the effect of legislation so as to give effect to section 101. So well, that's all I have to say on the approach to section 101, subject to any questions. That's section 101 on section 154 of the Government of Wales Act in principle, but the application to the facts or the particular bills in question here are not the concern of the Counsel General for Wales.
Well, there don't appear to be any questions for you, Ms. Matfield. Thank you very much for your assistance. We appreciate the Counsel General's participation in the hearing.
Thank you for the opportunity to be here.
Sir James.
My Lords, I wanted to address three topics very, very briefly in relation to section 28(7, and then a few topics, not many, under 101, and then finally to pick up the central theme of my learned friend Miss Mountfield's submissions about international law, if I may. That's going to be the structure of it. The first of the topics under section 28(7 relates to the continuity bill case. And the attempts by my learned friend Mr. Muir to distinguish it on the basis that the issue in that case involved two things, he said, which served to distinguish it. The first of them was the imposition of an external actor, in that case under section 17 UK ministers. And secondly, that section 17 there would mean that the legislation was made, as he put it, of no effect. And our submission in reply is that neither of those are relevant points of distinction, and neither of them deals with the reasoning of this court in continuity bill. As to the first of them, the role of the external actor, as he puts it, did not play any part whatever in the reasoning of the court in continuity bill. The court's reasoning concerns a condition imposed on the legal effect of laws made by the United Kingdom Parliament. It doesn't matter who put the condition there. What matters is that the condition was put there. And of course, in this context, you will bear in mind that it is in any event an actor external to the Scottish Parliament, which is put in charge of the process. It will be the Scottish courts. So the point of distinction, the first point of distinction, fails on its own terms and is wrong in any event in principle. And there was no proper answer made by my learned friend Mr. Muir to the point that the delegation by these bills had occurred to the Scottish courts of both the competence question and the compatibility question, and that meant that the Scottish Parliament could not claim the benefit of its democratic mandate in relation to Westminster legislation, because it has offloaded the relevant decision-making to the courts, who, for all their other virtues, plainly do not have that same democratic foundation. So that's the first point of distinction about external actor. The second point of distinction was that section 17 in the continuity bill case would mean that the legislation made was of no effect. And my submission in relation to that purported ground of distinction is that there is no difference of principle between the Scottish Parliament's provisions causing legislation to be of no effect and it being rendered as having a different effect to that intended by the Westminster Parliament through the use of Section 19, or indeed to strike it down under Section 20 or to declare it incompatible under Section 21. In all of those contexts, Parliament's ability to legislate for Scotland and to do so effectively is materially qualified when it wasn't previously. And that links into the sole purported ground of distinction advanced by Miss Mountfield in relation to the Continuity Bill case. She says that there's nothing in the UNCRC bill, to take that as an example, equivalent to the provision in the Continuity Bill case. But we submit that our context in relation to the UNCRC bill and the Charter Bill is a fortiori the position when compared with the Continuity Bill position. And that is because, and precisely because, the powers that are purportedly conferred on the Scottish courts by those bills are powers to give Westminster parliamentary legislation a fundamentally different meaning, powers to strike down Westminster parliamentary legislation, and powers to declare that sort of legislation incompatible. All, I would add, and I'll come back to this point, with the continuing legal effects that were flushed out during the course of the morning that are given to the unlawfulness that would then follow were any public authority to continue to rely upon the provisions which had been the subject of either that interpretation or those declarations or that strike down, with the right to damages accompanying all that. So we respectfully submit that there is no valid point of distinction by simply saying, well, Section 17 would say that legislation was of no effect. Makes no difference. So they're both non-points of distinction, we respectfully submit. Finally, in relation to the Continuity Bill issues, my learned friend, Mr. Muir, simply did not deal with the reasoned underpinning for the rejection in that case of the three submissions that the Lord Advocate had there advanced. For example, the Lord Advocate in that case made a submission which was mirrored by a submission made by Mr. Muir in this, namely that the power of the United Kingdom Parliament was not touched because it can continue to make laws for Scotland. The difficulty, of course, with that is that it will have to address the UNCRC every time. And precisely that sort of argument was run in the Continuity Bill case and was rejected. But nor did he have any principled answer to the point that one cannot, pursuant to the underpinnings and the reason for rejecting the second of the Lord Advocate's submissions in Continuity Bill, as you recall, the temporal incoherence point, he had no answer to that point at all, namely that it is not permissible, having regard to the structure of the Scotland Act and the need to judge whether something is either law or not law under the provisions of the Scotland Act. You've got to judge that on the basis of current statutory provisions, and it's not competent, it's not possible to turn around and say, well, things might change. Someone might do something differently. The Westminster Parliament might act in a different way. The Scottish Parliament might act in a different way in the future. That is no answer to the current issue, the current problem that is competence. So that's what we say about Continuity Bill. My learned friend Mr. Muir's general answer to our submissions and the core of his oral submissions appeared to be that the Scottish Parliament had competence to, as he put it, condition the continuing legal force and effect of provisions of acts of the United Kingdom Parliament. And our submission with respect is that that isn't a sufficient answer in the present context in relation to these bills. It isn't quite clear what that submission means. It appeared to be framed by reference to the Scottish Parliament's powers, which are undoubted, to amend and repeal United Kingdom Parliament legislation within devolved competence. But of course, none of the referred provisions of either bill which is before you expressly or even impliedly amend any provision of a UK Act of Parliament, just as the HRA doesn't per se amend every other act conferring a function on a public authority. Rather, what is done under these bills is to overlay entirely general additional restraints on how unspecified functions provided for by UK Acts of Parliament apply. And moreover, to delegate under sections 19 to 21 of those bills, of the UNCRC bill, the control of those unspecified functions to the courts. And that is of particular concern because, as I pointed out in opening, it bypasses the designated constitutional actor in relation to what can only be a legislative function. And it bypasses the designated and very important associated procedures for checking, ensuring, and testing competence specifically provided for in sections 31 to 33 of the Scotland Act. And it's no answer to that to say, well, devolution issues arise in various other contexts and may be considered by the courts. So they may. But the Scotland Act has set out the advance model, one wants to call it that in summary, to ensure competence and very swift checking of acts where there's a question about competence passed by the Scottish Parliament. So our submission is that an amendment or a repeal has actually to be confronted. It's actually got to be done expressly or at least clearly impliedly by the Scottish Parliament. And that is not what is being done in the present context on any view. So the answer to the question that Mr. Muir posed, if it was a glove being thrown down for me, if the Scottish Parliament can repeal or amend, why can't it introduce a new rule of interpretation applying to UK acts or UK parliamentary acts, is because it's not an amendment. That's the fundamental disconnect. It's a separate and general overlaid constraint or rule applicable both to existing and future legislation, allocated to the court. It's not section 19 which amends anything. It authorises the court to modify the effect of UK parliamentary legislation, and that is materially and fundamentally different to the constitutional legislative exercise with all the checks and balances in the Scotland Act that the Scottish Parliament may in certain circumstances exercise as a function, namely to make its own legislation which amends or repeals. The final topic under 28.7 is to focus very briefly on points relating to the specific provisions in sections 19 to 21 of the UNCRC bill. And the submission really reinforces the debate which occurred this morning, if I may respectfully do so, in relation to section 21, to take that as the example of the UNCRC, read with section 6 of the UNCRC bill, you end up in a very odd position indeed. So far as the parties are concerned, so far as the relevant actors are concerned, who are almost always going to be public authorities enforcing a relevant legislative scheme passed by the Westminster Parliament, sections 20 sub 4 and 21 sub 4 have no real effect at all because of the absence of anything like section 6.2 of the Human Rights Act. What that absence opens up is the possibility of claiming and getting damages on just satisfaction grounds if any public authority enforces the legislation subject to a declaration or a strike down. So the legislation effectively becomes a dead letter because otherwise the public authority is exposed to an unanswerable claim for damages. And the significance of that, apart from illustrating the incoherent and ill thought out nature of this legislative scheme, is that it indicates that the answer given to the point that Section 21 modifies the United Kingdom's Parliament's ability to legislate for Scotland, in other words, that the impugn provision would remain in force and continue to have legal effect, is untenable. If the public authority enforces the provision of the UK Act of Parliament in question, it's exposed to damages. And that in itself, it might be thought, is a modification in its own right, as I think Lord Stevens pointed out in the course of discussion. And the same point applies in relation to Section 20 sub 4, and the same point applies in relation to Section 19(4). So those are the points I wanted to make by way of reply on Section 28(7). Can I turn then very briefly, my Lord Stevens?
Yeah, so just before leaving sections 6, 7, and 8, a public authority is in fact includes the UK Parliament.
It does.
And so one's envisaging claims for damages against the UK Parliament for passing legislation which is inconsistent with, incompatible with the UNCRC.
Well, that is possible too on the face of the legislation.
Yeah.
I mean, that's a.
And does that modify the powers of the United Kingdom Parliament?
Well, might be thought it might do fairly obviously. But if I may say so, that's a discrete and separate issue to the broader one, which is really the one I've been on, which is really a structural problem with the legislation in this form. Can I turn then to Section 1012 briefly? And that is an issue which, as you recall, principally arises in relation to Section 6 of the UNCRC bill, because it is accepted by the Lord Advocate that sections 19 to 21 cannot be read down. And for good measure, the Lord Advocate also accepts that there will be respects in which Section 6 is outside competence. And I wanted to make submissions, if I may, on 3 or 4 topics in relation to this set of issues. The first topic relates to existing case law. On the application of 1012, the Lord Advocate repeatedly made the submission that its use to render Section 6 with incompetence is no different to the use that has been made of Section 1012 in the existing case law. And I respectfully do not accept that properly characterises how Section 1012 has in fact been used to date by this court. 2 main examples. The first is the Bylaws Bill case. You've been back to it frequently, paragraph 64, Lord Neuberger at page 815 in the electronic bundle, and its application to the apparently unlimited and general effect of Section 9 of that bill. But it's important to understand that Section 101 was having to solve a very discrete and narrow problem in that case. Section 9 of the bill, as explained at paragraph 60 of the Bylaws Bill case, 814 in the electronics, enabled the Welsh ministers to add to the list of enactments under which UK ministerial consent would no longer be required for the making of local authority bylaws. And the vice of that, as indicated at paragraph 61, was that Section 9 did not exclude pre-existing enactments which gave UK ministers such a function, and so appeared to breach a particular competence restriction then in place on the Welsh Assembly's legislative powers. And Lord Neuberger agreed at paragraph 62 that if it applied to such enactments, it would be outside competence. But it is that scope which was read down using the equivalent of 1012, and it'll be immediately apparent that the competence issue was a very much narrower one than in relation to Section 6 here. The whole of the bill was only about enactments relating to the power of local authorities to make bylaws, and that issue only arose in relation to such enactments which gave UK ministers a confirmatory function. So although the language of Section 9 was indeed general in the case, the subject matter of the bill was narrow, and the competence issue that Section 1012 needed to be wheeled out to solve was a narrow and very specific one. And unsurprisingly, therefore, 101 could achieve a clear and certain result. The second example given is the Continuity Bill case itself at paragraph 77, page 869 in the electronics, which in this context concerned the apparently unlimited power on Scots ministers to bring into force section 33 of the bill, which would remove various references to EU law within the Scotland Act, including the controls on competence. As explained at paragraph 75 of that case, the concern referred was that this power could be exercised on its face before the UK had exited the EU, and at a time when it would have been outside competence to remove the EU law-based restrictions. And in those circumstances, the court held that 101 could be used to read the power to make regulations, bringing section 33 into force only at a point in time when the Scottish Parliament would be competent to do so. Again, general wording used in the bill, but again, the competence issue was a narrow and specific one, with section 101 effectively resolving a binary question: can the power be used before exit from the EU? And again, possible to use the provision to achieve a clear and certain result. So we respectfully submit that neither of those two cases does anything other than reinforce the submission that section 101(2) has its limits. You need to be able to identify a clear and certain result. It isn't a salve for all drafting ills. That's the first topic. The second topic is the Belmarsh decision, and we provided that to the court. I hope you've had it separately this morning. In that case, as you will recall, at paragraph 33, Lord Bingham was considering the proportionality of the derogation from Article 5 of the ECHR required for Section 23 of the ATC-SA, the Anti-Terrorism, Crime and Security Act of 2001, which permitted the detention of foreign nationals suspected of terrorism who could not be deported. That was the subject matter of it. And that paragraph, paragraph 33, concerns what is effectively a rationality concern, namely that the legislation permitted a foreign national voluntarily to leave the UK, even though he might pursue terrorism in, say, France, because he was a member of ETA. The Attorney General in that case, as some of us recall, offered a concession that the provisions would only be used for those suspected of links to Al-Qaeda, and the appellants accepted that. Lord Bingham did not, holding, as he put it, that it is not, however, acceptable that interpretation and application of a statutory provision bearing on the liberty of the subject should be governed by implication, concession, and undertaking. And we submit that Belmarsh provides powerful support for the general concern that the law officers have raised on this part of the reference, that section 101 is in our context being asked to bear far too heavy a load in circumstances in which the Scottish government concedes in the bill documents that they are effectively relying on 101 to fix their drafting choices. What Lord Bingham's concern highlights is a general rule of law concern, particularly where the context of the provision is of real legal and practical significance, as section 6 would be, of the UNCRC bill would be, that controls should be apparent on the face of the law and as a matter of legislative choice and not judicial interpolation. And that is a real concern in a context in which both the rule of law generally and human rights considerations place high on the list of virtues certainty and clarity, and in which one is dealing with careful distinctions of real importance in the context between the roles of the different constitutional actors in play. The attempt by my learned friend to distinguish Belmarsh and those issues and those concerns on the basis that Belmarsh involved the liberty of the subject fall apart. They fall apart firstly because Lord Bingham's concern is a general one, based as it is on rule of law considerations. And secondly, and specifically, falls apart because the UNCRC may very well also impact in such a context in a variety of different ways on the liberty of the subject. So we submit that whatever the term possible encompasses in 101, firstly, it does not permit an approach that simply throws the cards in the air and invites the court to sort out the lines. Secondly, it cannot encompass the court adopting a reading or an interpretation which does not resolve the application of the provision in question with real certainty. And thirdly, it cannot invite the court to start attempting to strike what are in effect legislative boundaries. And I come back to a point I made in opening very briefly, which is that nowhere in the bill documents for the UNCRC or the Charter Bill, or in the Lord Advocate's case, or really in his oral submissions until prompted, is there any specificity provided as to how 101 is in fact to apply? How is it in fact to be interpreted to control the beast that is Section 6? What is the narrow reading that he contends for? And his oral submissions, we submit, failed to provide an answer either. In the end, in answer, I think, to a question by my Lord Stevens, he accepted no words. There's no words, there's nothing you can put into Section 6. And what he was effectively then driven to rely upon was a control through the very complicated provisions on competence under the Scotland Act generally. And he then said, because that was the inevitable follow-up question, well, the results of all of that exercise, if only you could do it, would be both intelligible and foreseeable, with legal advice, as he put it, and then after a bit of a thought, and with litigation, which prompted Lord Lloyd-Jones, correctly, if I may respectfully say so, to ask the question, by which you mean a whole series of cases sorting out those lines. We submit that that is not a satisfactory answer to the legal certainty concerns to which Section 6 gives rise. It is not consistent with the idea that competence issues should be addressed and pre-cleared effectively by the Supreme Court if controversy exists at an early stage. And it would mean ultimately that everything is within competence, if only generally enough expressed, because the courts would, if invited after lots of litigation, tell you when that was in fact so and not so. And the specific problem that arises, or the particular problem that arises in relation to Section 6, is the sheer number of issues that would have to be resolved. This is the final point on Section 101. But no doubt one can construe general words in certain contexts, a bit like was done in the two cases I mentioned earlier, the Bylaws Bill case and the Continuity Bill case. You can no doubt construe general words under 101 to contain things if the answer is that you've got a clear and certain answer and you're not trespassing on constitutional boundaries. But the sheer number of issues point is a real one, we respectfully submit, both because of their number and because they are effectively legislative choices. And as such, they layer a constitutional objection on top of the certainty one. 4 examples perhaps might do in relation to the competence issues avoided by the Scottish Parliament and left to the courts to resolve using Section 101(2). But we know that it is accepted, this is the first one, we know that it is accepted and has always been accepted that Section 6 cannot in fact apply to the bodies listed in paragraph 3 sub 2 of part 3 of Schedule 5, Electronic 673. Conferring functions on them is expressly reserved. One example relevant to this bill is the EHRC. But how does 101 work to read in a list of additionally entirely excluded public authorities where one is already listed in Section 6 3b of the UNCRC bill, but no others? Can that truly be done in relation to the structure of Section 6 as it is? We submit very difficult. But secondly, Section 6 applies directly, without apparent limitation, to a court or tribunal. Section 6, sub 3, sub A, Roman 2. But for some, that will only apply in particular contexts. Lord Reed's example of the IPT, you've already thought through and don't need me to exhibit and to go through again. But the same point goes to any number of other UK public authorities, including UK ministers, whose functions will be generally reserved, but who may have some devolved functions. Thirdly, one of the scheduled UNCRC requirements is Article 26, which provides for a right of a child to benefit from social security. See page 60 of the bundles electronically. However, heading F1 of Schedule 5, page 632, reserves social security and benefit schemes from local or central funds, and there are then a detailed array of exceptions which are not reserved, including in exception 3, some specifically relating to children. See page 633. How, it may be asked, is 101 to apply to draw the lines as to which forms of benefit decision applicable to children are within competence, such that Section 6 will apply to those decisions and which remain reserved and outside competence? But those who we respectfully submit are not merely problematic in terms of decision making for a court. They are detailed and complex legislative policy choices with significant potential resource implications. Fourthly and finally, then, by way of example of the work that Section 6 is set to labour on, the Lord Advocate's case at paragraph 75 asserts that the obligation in Section 6 to act compatibly with the UNCRC requirements may not amount to a modification of the law on reserved matters contrary to Schedule 4, paragraph 2.1 at page 543, because the duty might be incidental to or consequential on a permissible modification within paragraph 3. See page 545. Even assuming that such a significant duty could ever be characterized as incidental or consequential, which we don't accept, how is 101 to be read, and how is it to be read so that this a complex control and exception to the control fits into Section 6? So those are just 4 examples of the work that 101.2 is being asked to do on the Lord Advocate's case. And you have the submission that it is one thing to say as a general proposition, if you have general words, 101 can provide a limit. But what the case law in this court makes absolutely clear is that you can use it only if you can achieve a clear and certain result. Nothing in this court's case law indicates that it can be wheeled out to make these sort of difficult and complex choices, and that matter is simply left to the courts. Finally, in relation to 101, we note that there was almost no, or indeed no, real answer to the points that I made about the difficulties, the specific difficulties of deploying 101 to try to sort out the issues relating to sections 4 and 5 of the Charter Bill. So that's what I wanted to say on 101. The final topic, my lords, is the point that my learned friend Miss Moutfield laboured long and hard on, which is the idea that really all Section 19 of the UNCRC is doing is simply to introduce a non-controversial principle of interpretation that's already well established. And there is a real difficulty with that. We would strongly urge the court against having to decide, I don't think you do, but we would strongly urge you not to decide, any sort of general proposition that even in the context of the introduction of legislation which is specifically designed to give effect to an international convention, there's anything like a strong presumption, still less that the principle of strong presumption is in some way a general canon of interpretation. That's highly controversial and does not need to be decided to dispose of the issues in this case. It may be as well to start with some of the basics. International law is not part of domestic law. Our system of laws is dualist. And what that means is that you need a vehicle. Under our constitutional arrangements, you need a vehicle to bring international law into domestic law. There are vehicles. They've been identified and thrashed out over the years in the case law. And we know that one of them is to use international law as an aid to the interpretation of the nature and scope of the rights under the ECHR, because that's what the European Court of Human Rights does under the Demir principle. And that was what was fundamentally in issue, and that was the gateway in the SG case, as my lords will recall, some of you will recall. So that's one gateway, and entirely permissible, because under the Human Rights Act, there are scheduled rights that are brought into domestic law, and in order to understand their content and meaning, you effectively apply the same approach to interpretation that the European Court provides. And so you have there domestic legislative permission, in effect, the gateway, the vehicle, if you will, to bring in international law. The second one, which is a relevance perhaps, is ambiguous legislation. But you need ambiguity. And the reason you need ambiguity in constitutional terms is because if you don't have ambiguity, you're using international law effectively to disagree with or disapply a clear provision of legislation that Parliament has seen fit to enact. And that's constitutionally impermissible. That is why the principle of ambiguous legislation as a necessary gateway exists. And that is no doubt why, in the SG case itself, there was the very clear exposition of precisely this gateway analysis, with ambiguity in legislation specifically identified in the judgment of Lord Hughes at paragraph 137 in the electronic bundle at 2076. So that's the basic constitutional position. After a bit of pressing, it became clear that what my learned friend Miss Mountfield was really arguing about was the meaning and effect of section 19 of the UNCRC bill. But we respectfully submit that there are short answers to that attempt. It self-evidently does not simply replicate a usual position of interpretation. And it self-evidently does not do so, because if that's all it was doing, it would be unnecessary. What's the point of it? You don't need the statutory provision at all. The plain and obvious intention, modelling it or attempting to model it at least relatively closely on section 3 of the HRA, was to change the law so as to bring in a provision of real strength that would enable the Scottish courts to do something different to that which they would otherwise be able to do. And so it's untenable to make that submission about the meaning and effect of section 19. It's equally untenable, we submit, to use that position as the stepping stone to try to draw the sting from the idea that the UK Parliament in future legislation would have to legislate so as to avoid that new interpretive consequence. So for all of those reasons, we submit that the central theme of her oral submissions is just entirely untenable. Well, those were my submissions in reply, unless I can seek to assist further.
Thank you very much indeed, Sir James. There don't appear to be any remaining questions. We're most grateful to all counsel and those who've been assisting you all for your submissions. We'll endeavour to give judgment as soon as we can. The court will now adjourn.